Hi, everyone. How are we? Okay. Today, what I want to do is listen to the judge's thorough sentencing of Darrell Brooks. Now, I might have to piece this out in to more than one video, but let's get started on it and kind of do like a group watch of the sentencing over. He has, just to let you know where I'm starting off on this video, he has already done his little stupid, you know, rant at sentencing. And the victim impact statements happened before that. So now we're at the point where the judge says, okay, now it's my turn. So let's go forward with this. He's looking awfully nervous there. You see his arm, his right arm's flinching. He's probably shaking his leg. I think in his mind, he doesn't believe that he's going to get life. He knows he's going to get something. But I think he's so dumb that he actually believes that he proved his case, or that she's going to go soft on him. I bet he does think she's going to go soft on him because she let him get away with some stuff that a lot of judges wouldn't. So it's probably his mindset right now. You know, he's like, okay, she's gonna, yeah, because I got her wrapped around my finger. If I tell her to come, she gonna come. Like he did with his mama, but we know that didn't work, right? Yeah, no, it didn't work. So you guys, where were you when you were listening to the sentencing? I'd like to know if you were here on this channel or elsewhere, or where you were physically. Like, were you in your car? Were you at work? A lot of you guys are going to be at work, probably. I was sitting here on my live stream, just soaking it all in. It was just fabulous.
Thank you, everyone. Please be seated. All right, we are back on the record and state versus Brooks. Appearances are as they were before. I want to give you all a little bit of my roadmap for my remarks here today and what will ultimately conclude with the sentencing. I'm going to start with a review, frankly, of Mr. Brooks's NGI plea. I wasn't going to start out doing that, but I feel compelled to make a record of certain things in light of many of the statements that were made here today by Mr. Brooks and his family. Following that, I'm going to talk about the case, the strength of the case, the witnesses and evidence that was presented, and some of the things that really impacted me throughout that time, and throughout the nearly 4 weeks of trial. Then I will spend some time talking about the victims, their victim impact statements, and again, things that have stood out here to me. I cannot comment on all of the victim statements but there are a few that I do want to highlight. And then ultimately go through the sentencing factors. Because all of these things I'm going to talk about relate to those factors, which in Wisconsin, there are 3 primary factors: the seriousness of the offense, the need to protect the public, and the character and rehabilitative needs of the defendant. So I want to start sort of near the end of all of the remarks over the last couple of days, and that is with my thoughts on Mr. Brooks and his mental health. I'm not here to debate that you have had a history over time of intersecting with the mental health agencies, and that you may have in your history trauma, emotional pain, and things of that nature. I have read through not 1, not 2, not 3, but 4 reports from experts, people who are well known in this field of what we call forensic psychology and psychiatry, individuals who have an expertise in evaluating a plea of not guilty by reason of mental disease or defect.
She's
Because
fixing
I
to
don't want there
debunk
to
you.
be any doubt in my sentencing here today that I've considered that. But I
Debunk.
also don't want there to be any doubt that somehow this trial was missing something. Because the fact is, Mr. Brooks entered a special plea of not guilty by reason of mental disease or defect in the early summer, maybe late spring of this year. And this court ordered 3 court-ordered evaluations, and the state retained an expert to also review the issue. Whether at that point ever hired anyone, they are not required to disclose that. I don't know, but I have 4 well-known doctors who have written this court based upon the orders that were made or one doctor being retained. And these are reports that are thorough. One report is 24 pages. Another is more of a summary. It's 8 pages. Another is 26 pages. And then another is 12. And they look at the discovery information. So police reports, videographic evidence, things of that nature. They have access to any mental health related records from prior stays or things like that. They look at a history. They meet with Mr. Brooks. I've referenced this in the past when competency wasn't so much raised by any of the parties here, but during the trial, there was, as Attorney Opper wanted to make a record one day of Mr. Brooks's competency. And I will restate what I stated at that point. I have absolutely no doubt that Mr. Brooks is competent. I'm obviously well-versed in the legal standard, but that is not something that this court was frankly ever concerned about at any point in time. I know that his attorneys, when he had attorneys, never raised the issue.
Yep.
And it was really only after the trial began that issue was raised, I think, by the public based upon what they saw. But
because they only saw the
Attorney
crazy
Opper,
parts.
like myself, had the benefit of having reviewed each and every one of these examinations. And I'm not going to spend a lot of time, but I think it's important because it goes also to Mr. Brooks's character, which is one of the things that this court must consider along with his rehabilitative needs. And I'm going to read parts of these evaluations so that you all understand the information that I have and why it is my opinion that mental health issues did not cause him to do what he did on November 21 of 2021, and frankly did not play a role. That's not to say that he wasn't diagnosed with something. I've referenced this previously, but that's an antisocial personality disorder.
Look at him.
And this is what one of the reports has to say. They've looked at.
He's getting pissed.
One doctor indicated that there was available evidence to sustain a diagnosis of cannabis abuse, intoxication, antisocial personality disorder, adjustment disorder with mixed disturbance of emotions and conduct. And the reports go on to describe what those things are and that they may qualify as an abnormal condition of the mind substantially affecting mental or emotional processes, and thus as a mental disease or defect as broadly defined by the Wisconsin jury instructions. And that's at least as to the adjustment disorder. Cannabis abuse or intoxication would not. The diagnosis of antisocial personality disorder, and this is what the doctor said, reflects converging support of an underlying characterological disorder versus a major mental illness. In Mr. Brooks' case, I would note his history of disregarding the rights of others and conforming to societal norms, including in the forms of multiple acts of violence beginning in his youth, contacts with the criminal justice system, lack of remorse as indicated by being indifferent, rationalizing, etc. The doctor goes on that it's her understanding that this characterological condition would not qualify as a mental disease or defect, as defined by the applicable statute, which also specifies that mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Goes on to talk about her opinion regarding criminal non-responsibility. And the examiner rendered an opinion to a reasonable degree of professional certainty that there was not support for the defendant's special plea, that the facts at hand do not sustain a conclusion to a reasonable degree of professional certainty that because of symptoms of a mental disease or defect, Mr. Brooks was rendered to lack substantial capacity either to appreciate the wrongfulness of the alleged misconduct or conform his conduct to the requirement at the time in question. In arriving at this opinion, the following considerations were significant to this examiner. While acknowledging Mr. Brooks' documented history of episodic contacts with mental health professionals beginning in adolescence, most of the time he has had such contacts or received mental health treatment when in custody. In effect, there is not a sustained, documented history of a diagnosed major mental illness for him predating the alleged offense or otherwise. Looked at a psychiatric review from April of 2010. At that point, the defendant was determined to have no medically determinable impairment on which to qualify for disability benefits. The consultant who conducted the review noted that Mr. Brooks' claimed mental illness was not, quote, well established, quote, that the statements that he made at that point were not deemed credible, they were inconsistent and not verified by treatment providers in the community. Factor number 2, the defendant's history of violence beginning years predating the alleged offense is significant. He faced multiple prior domestic related charges. He was not permitted in his mother's home because of the history of violence. To be sure, the magnitude and lethality of Mr. Brooks's violence in the commission of the alleged offenses is more severe than what was previously known. However, the defendant's history of a pattern of violent behavior, coupled with other aspects of his history, and this case strongly suggests that his mental state, which produced the alleged offenses, was most fundamentally formed and fueled by contributions of his underlying characterological dysfunction, anger, and rage born of his conflict with his girlfriend moments before Christmas tragedy. The examiner considered Mr. Brooks's episodic endorsement of auditory hallucinations, including on clinical interview with the undersigned, meaning the examiner, and in a couple of recorded jail phone calls subsequent to his arrest. She said this, "I am unaware of any objective corroboration that he presented either in the hours leading up to or following the alleged offenses as internally preoccupied or otherwise exhibiting signs of impaired reality, contact, or behavioral discontrol. To the contrary, the defendant's conduct within hours of the onset and moments following the alleged misconduct was organized, controlled, and purposeful. Moreover, he demonstrated the motivation and capacity to take efforts to evade detection and try to flee the immediate area of the parade carnage." She went on, "I have considered the seemingly inexplicable nature and magnitude of the violence and mayhem wrought by the defendant's conduct on the day in question. He has caused 6 deaths, dozens of injuries, and terrorized hundreds of parade participants and thousands of spectators. There is no indication in the extensive compilation of records and other information available that at the time of the alleged misconduct, he lacked substantial capacity to either control or conform his conduct to the requirements of the law, or that his reality contact capacity to appreciate wrongfulness was substantially impaired. In the context of rage born of his conflict and altercation with his former girlfriend turmoil, the defendant was disinclined to control his behavior or attend to its consequences. Notwithstanding the magnitude of the violence in this case, a mental disease or defect is not defined by the unnaturalness or enormity of the act. Moreover, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy, or the like does not constitute a mental disease or defect. She goes on to talk about the course of functioning of Mr. Brooks during the day leading up to the alleged offense. Does not suggest that he was behaviorally dysregulated or that his reality contact was impaired. Goes on to talk about what he did in the immediate aftermath of the parade, including fleeing the vicinity, making efforts to evade detection or responsibility, and other things. Went on to discuss other evidence, including the videographic evidence of the Ring doorbell and being on the porch where he sought to use the phone. He had apparently discarded a couple of small bags, later determined to contain marijuana. And presumably, this is the examiner again, he discarded items to evade responsibility for possessing them. By implication, such conduct strongly suggests his capacity to appreciate wrongfulness was then intact. When responding to law enforcement officials, he followed their commands. He lowered himself to the ground. We saw that on the recording of his arrest when he was taken into custody and detained. None of the behaviors nor verbal remarks at the time of the arrest suggest he was behaviorally dysregulated or that his reality contact was impaired. Following his arrest and being taken into custody, he engaged in an informal series of verbal exchanges with authorities. And none of his statements taken at face value suggest he was then actively psychotic or that his behavior controls were substantially impaired. She then goes on to talk about the Mirandi statements. This court personally watched every minute of that interaction with Detective Carpenter and Detective Stern, along with the one from the night before, which was at the hospital within hours.
They saw how crazy he was, or
And I
how
would concur
narcissistic.
with the examiner's conclusions that the content of his initial statements to authorities included multiple efforts to deceive or mislead. He changed his story multiple times, including he initially denied being in Waukesha the prior Saturday. He initially asserted he traveled to Waukesha on the day in question in a tan Kia with a friend. He initially asserted his mother did not own a vehicle, though later acknowledged as much, and that he used it from time to time. Other changes in his story over the course of his statements and the nature of them further suggest that he was making active attempts to evade detection or responsibility. By implication, such behavior strongly suggests that his reality contact was then intact.
Preach.
When he was shown photographs of driving in the SUV into the parade route, he indicated it was not him. And this is again the examiner. With the police. She's noting the police contact. It was not until Mr. Brooks was in the booking area of the Waukesha jail that he displayed some emotion. And this was to, I believe, Detective Stern, where he said, "I didn't mean to kill nobody." Such a remark indicates an awareness of the consequences of his actions and runs counter to a conclusion of an exculpatory mental disease or defect. There's other criteria or other factors. I'm not going to read them all. That was probably one of the more comprehensive explanations of why that examiner did not conclude that there was support for the special plea of not guilty by reason of mental disease or defect.
He's
All
so
four
mad.
examiners shared similar observations. Certainly their conclusions were that there was not support for the special plea. One examiner talked about, again, conduct after driving through the parade, abandoning the vehicle used in the act, altering his appearance by removing his outer layer of clothing, altering how he was wearing his hair, and then engaging in further efforts to leave the scene by securing transportation via a ride-sharing application. This particular examiner went on to say, while he essentially, meaning Mr. Brooks, disclaimed any memory of those actions and could therefore not explain them, such behaviors strongly suggest an awareness of wrongdoing and a desire to avoid detection.
All that hiding he was trying to do.
Another examiner had very similar things: antisocial personality disorder with borderline features, talked about the cannabis use disorder and full remission in a controlled environment. What's interesting about this particular report is the description of an antisocial personality disorder. The DS defines antisocial personality disorder as a pervasive pattern of disregard for a violation of the rights of others occurring since age 15 years, as indicated by 3 or more of the following: failure to conform to social norms with respect to lawful behaviors, as indicated by repeated performing acts that are grounds for arrest. 2, deceitfulness, as indicated by repeated lying, use of aliases, or conning others for personal profit or pleasure. 3, impulsivity or failure to plan ahead. 4, irritability and aggressiveness, as indicated by repeated physical fights or assaults. 5, reckless disregard for safety of self and others. 6, consistent irresponsibility, as indicated by repeated failure to sustain consistent work behavior or honor financial obligations. 7, lack of remorse, as indicated by being indifferent to or rationalizing having hurt, mistreated, or stolen from another. In addition, the individual is at least 18 years old and there's evidence of a conduct disorder prior to the age of 15. This examiner noted Mr. Brooks meets nearly all of the symptoms described above because he has exhibited a long-term maladaptive pattern of behavior involving a disregard for and violation of the rights of others, beginning in childhood and continuing through adult life. The borderline features reflect a general inability to sustain healthy relationships with others, including his domestically violent relationship with victim PPP.
Uh-oh, here we go.
That examiner goes on with further analysis and conclusions, again, finding that there is not support. The last examiner, again, made similar conclusions, also diagnosing Mr. Brooks with an antisocial personality disorder. Why is that important? There is no doubt that in our criminal justice system today, we face a crisis of the mentally ill intersecting in our courts. In the last year and a half alone, this court has ordered many competency evaluations, presided over a number of contested competency hearings, and ordered many, many evaluations for the special plea of not guilty by reason of mental disease or defect. And the bottom line is, for this court, Mr. Brooks does not present as a person who is either not competent or not guilty by reason of mental disease or defect. It is frankly heartbreaking to see those individuals who truly suffer from schizophrenia, for example, intersect
Thank you, Kathy.
Our criminal justice system. Sometimes they do unspeakable things. They hurt other people. I'm thinking of one such gentleman who was so schizophrenic and out of control. He couldn't even be kept in the courtroom. He was too loud. He clearly, if you've ever been in the room with someone who is suffering from auditory or visual hallucinations, it is not something you easily forget. It makes an impression, even on someone like myself, who's not an MD or a doctorate level psychologist. I've been in the room with an individual who was, when I did defense work, and he was accused of killing someone near and dear to him. It's a very, very different presentation. It's heartbreaking. It's heart-wrenching. Do the mentally ill sometimes commit atrocious crimes? They do. This is not one of those situations. We've heard Mr. Brooks's family talk about illness and bipolar. You know, in addition, and before I get to that, I've also had over my 11 years on the bench of coming face to face with evil on occasion. There are many times, good people do bad things, but there are times when evil people do bad things.
And yeah, you ain't good people.
There is no medication or treatment for a heart that is bent on evil. Child trauma, bipolar, indifference, physical abuse of a child, or even childhood trauma did not cause Darrell Brooks to commit the acts for which he will be sentenced here today.
Preach.
It's very clear to this court that he understands the difference between right and wrong, and that he simply chooses to ignore his conscience. He is fueled by anger and rage. Some people, unfortunately, choose a path of evil. And I think, Mr. Brooks, you are one of those such persons. As a mom, my heart breaks for your family, for your mom, and for your grandmother. The son that she raised, the grandson that your grandmother knew, the hopes and dreams they had for your life, they're gone.
She's kinder
And
than
I
we
think
are
it's
about that.
perhaps far easier for them to blame a mental illness than to perhaps come to grips with their son did very, very bad things due to very bad motivations. One of the things ultimately that will happen when you are in prison, sir, is that the Department of Corrections, they are statutorily responsible for your care and your well-being, including your mental health. I do not have any authority to dictate to them where you go or how they treat you. That is far different than when there is support for guilty by reason of mental disease or defect, because then the court has available what is called treatment facilities and a commitment to such a treatment facility. That is something that is simply not on the table. And again, 4 evaluations, not even my own assessment, but 4 evaluations from licensed professionals say otherwise, even in the face of your family saying that, and even in the face of you claiming that. I'm not even here to say that some of those things can't coexist and you might not have some of your own mental health issues, whether it be bipolar, childhood trauma, or things of that nature. But the bottom line is none of that caused you to do what you did on November 21 of 2021.
His facial expressions have changed.
I want to next turn to
He knows it's over.
the trial in this case. And I think it's important that the sentence here today focuses on your conduct on November 21 of 2021 and the moments leading up to that tragic and fateful decision of yours to drive through the Waukesha Christmas parade. And of course, the moments after. I, of course, through my sentencing remarks and ultimately what I do here today, I can't answer all of the questions. I can't address all of the issues, including the why. Perhaps the one question that will remain unanswered. Why? Why did you barrel down White Rock Avenue? Why did you not stop? Why did you keep going? Many of us in this courtroom sat through the entire trial. And what we learned is that very early on in the afternoon of November 21, starting at around 1 p.m., the police got ready for the parade. The staging area was set up, and that was all along White Rock Avenue. Signs were put in place. Ultimately, barricades were put up at a number of locations on Main Street and surrounding that. We know, because we heard from Sergeant Warner about what he had done, and he had, right before the start of the parade, had driven down the parade route. It was on his shoulders, his responsibility to make sure everything was safe and in order. What's important about that staging area, sir, is we know that that is where the altercation with Erica Patterson really came to a head. We all watched that video.
Here we go.
Multiple videos. And we know that even before that, you appeared angry and upset. 2 individuals testified about you being at that mobile gas station, how you turned the wrong way down a one-way street, waved your hands in the air, rolled down your window, either exchanged gestures or words with one of the drivers. Perhaps 30 minutes or so before the start of the parade, maybe an hour or so before you drove down the parade route. But what's important is the signage. Even you, at one point, I believe when you were talking with Detective Carpenter, noted, it was my words, my assessment, it was clear something was going on. I think what you said was a lot of shit was blocked off. You'd driven past those signs on the staging area. The fact remains they were there, sir. And the fact remains is you told Detective Carpenter that. We then heard from the witnesses related to Ms. Patterson. We heard from Corey Runkle. We heard from Erica Patterson herself. My impression, based upon Erica Patterson's testimony, who, by the way, she showed grace and dignity facing you, the man who clearly has no regard for her as a mother of one of your children, as someone you had a domestic partnership with and a relationship with at one point.
That's not true.
We know, and I would say this goes to your character, what was shown through that altercation and going up the hill, following her, slapping her. You know, the rules don't matter to you, not the rules of the road, not the rules established by court orders, not the rules even of decorum and decency. And I'll get to this more fully when I talk about your character.
Get the popcorn out, y'all.
Went hard at Attorney Opper for her bringing these things up, but those are legitimate, lawful sentencing considerations. And when I get to that point, I'll tell you the case law that supports that. Your character, even your pending cases.
I don't need no case law.
We know at the time of all of this, right? You were out on bond for 2 felony cases, one involving a handgun, one involving the same vehicle in Erica Patterson, and one involving ultimately intimidation of Ms. Patterson. We know that on November 20th, and she was very contrite about this. She told you where she was. She invited you out there, and that you had contact with her on the 20th. There was some physical.
Contact with her on the 20th.
Mr. Brooks, this is my time. You need to not interrupt.
That's the reason why the charge was dropped.
Mr. Brooks,
the state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And now
Brooks,
you want to sit up here.
do not
now
interrupt me
you-
or you will be removed to the other
and now you
courtroom.
want to sit up here
Incorrect.
Stop.
and try to
Now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time
grace and all this. You talking about someone with 5 kids that don't have custody.
you need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right. He will be removed. He cannot simply stay
I don't
quiet when
consent
this
to being
court talks.
sentenced anyway. I don't consent to this. Just like I told you, I don't know the.
We'll be in recess until
don't-
he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
I don't consent to this. We all consent to it, though. How are we doing out there, guys? I don't like to talk over these videos because it annoys a lot of people, but I wanted to see while we have a pause here how everybody's doing. Can you guys hear me all right?
Seated, I need to first confirm that Mr. Brooks is able to hear and see the court. We do have the audio and visual on. If someone, I can see on the screen, there is a headset on the table should he choose, but I have confirmation that the audio and visual are working in the other courtroom. Before I continue, of course, Mr. Brooks does have a right to be present for his sentencing. He's been present all along today up until his disruption. It was very clear to this court that he had absolutely no intention of stopping his tirade. I think there's really no other way to describe it. And this court needs to go through remarks uninterrupted. And given the history in this case, which is well documented, of his disruptions and inability or unwillingness to follow the very simple rules of decorum and courtesy, which include not interrupting the court, I felt it important under Illinois versus Allen to remove him from the courtroom. As that is, of course, one of the options, and we have the benefit of the wonderful technology here in this courtroom and the adjoining courtroom. I believe is the equivalent of being present. What I have referred to at times during this trial as the functional equivalent of being present in this very courtroom. But it is important that I go through this without interruption to make the record that I need to make. I'm going to.
Yeah, we're going to do the whole thing. I think it's
Backtrack.
almost 3 hours long.
No, you're not muted, sir. You're going to listen to me and you're not going to interrupt. So I want to, I don't want to call it a tangent, but I'm looking for a note that I made. Then you need to pledge to this court, sir, that you will not interrupt me despite what you may not like me saying. Can you do that? All right, he's not making that pledge, and under Illinois versus Allen, unless he makes that pledge, he's not coming back into this courtroom. You are not. All right, clearly he's going to keep repeating that statement, so I have muted him at this point. It was my hope that he would honor a simple rule of courtesy and decorum, that he show respect to this court, to these proceedings, and not interrupt and talk over me, but that clearly is something he is unwilling or unable to do. I'll find my note that I wrote later. It had to do with, frankly, what this court has a pattern with Mr. Brooks, and that is when testimony or statements by the court or statements by the prosecution team become unfavorable to him, he lashes out and he disrupts. And that has been borne out time after time after time during this trial. So let me go through and pick up where I left off about the trial. I'm not going to go through everything in detail, but I think it's important that I set the stage, right, and the basis for my sentencing. One of the things that I did note regarding Erica Patterson's testimony, because frankly, I wasn't sure where Mr. Brooks was going to go with his own defense based on some of the remarks he made during his opening statement, which was actually later, but I guess I'll go back to my review of his recorded interview and some of the things that he tried to say. And at least it became apparent ultimately with the way he cross-examined witnesses. I wasn't sure if he would claim perhaps someone else was in the vehicle, he was afraid of police, the tinting of the windows, some of those things. Here's where it frankly doesn't matter. Okay, Erica Patterson provided key testimony in this regard, that there was no one else in the vehicle with Mr. Brooks. And I'm aware that he wants to come back, but until he writes me a pledge that he will not interrupt me under Illinois versus Allen, he is not coming back in this courtroom. He has forfeited his right to be present during my remarks. And unless he makes that pledge to me in writing, he's not coming back in. One of the things I tried to do in my preparation, and let me tell you, I reviewed all of my notes from this trial. I have, I think, 9 notepads. I looked at just a couple of exhibits, but primarily the map, Exhibit 15. I really wanted to determine for myself how long this carnage took. We know the distance, right?
He's getting his Bible out.
From at least where he entered. And you know what, Madam Clerk, put my screen up, will you?
Sure. Let me see. So we're in video conference.
I'm going to put Exhibit 15 up because I think it's worth doing that. All right. We know he entered from White Rock, where the first star is on the right side, where it says Fleet 1, unmarked sedan and marked SUV. And that's where Detective Casey was. And so we know he goes 1, 2, 3 blocks before striking anyone. And then it's really about 5 blocks of what can only be described as chaos and carnage. We know we have, from the evidence and the testimony, 2 different speed calculations. One from Bosco's, that was the surveillance footage, between 33 and 34.5 miles per hour. And then we have one farther down from the footage from Curry Insurance, where it was an average 32 miles per hour. Now, I acknowledge math is not my strong suit. I did not do a calculation, but I don't think it took very long for all of this to happen. I think it was a matter of minutes. I think 5 minutes would even be far too long. It's probably 3, maybe. And it was somewhat hard to gauge during the trial because of how the state presented. And I don't mean this as a criticism, but they were very meticulous in showing video, breaking it down, showing it at half speed, sometimes 30% speed, to really get an understanding of what was happening. And at no point did anyone ever tell me or tell the jury how long this took. But even though it took just a couple of minutes, there were so many opportunities for Mr. Brooks to simply stop, turn around, turn down other streets before he ever crossed Barstow Avenue. And what we know is that at 4:37, Detective Tom Casey had the first police encounter with Darrell Brooks. Came face to face. Detective Casey at the hood of the car, coming eye to eye. The SUV brushed past him. And here's the thing. Detective Casey said he wasn't going very fast. To me, that tells me he had ample time to reflect about what he was about to do. If you look on that map, it's not a pledge, he's not coming in. When you come down White Rock, you can take a hard left on East Main Street. You can take what I call a soft left. I believe it's Pleasant Street. And Detective Casey, you can correct me if I'm wrong. I can't see it on the map. Frankly, you can turn around at any point in time on White Rock Avenue.
Who's he talking to?
But instead, and I think if you all try to picture this, as difficult as it may be, there's squads with lights, there's barricades. I know I read in the other act's motion that Mr. Brooks claimed at one point he was having a panic attack, and he, again, maybe I think he was going to claim at some point he was afraid of police. Why drive toward them? Why take that right-hand turn? There's no reasonable explanation other than he was angry, he was full of rage, and he didn't care who he came in contact with, what he came in contact with, whether he drove past, through, at, he drove. Detective Casey pounded on the hood of that car, saw his face, again, was brushed by that SUV, thankfully not hurt. All of this preceded by the visual signs along White Rock Avenue of the staging of this parade, floats, bands, banners, signs, people. And as you got closer to Main Street, the spectators lining those streets, which both, I believe, Detective Casey and Sergeant Warner said were thousands of people. Before he ever gets to Barstow Avenue, he comes in contact with, after Detective Casey, Officer Buttrin and Officer Schneider. He has an opportunity, if you look at this map, he could go right on Buckley. Again, there might be police, there might be barricades. You simply stop. You ask, can I get out? No doubt in my mind, any police officer there would have done just that. He could have gone left on Northeast Avenue, continuing down. He could have gone left on Martin Street. Continuing on Barstow Avenue. This is where the parade participants, unfortunately, he has contact with them, but he could have gone right on Barstow. He could have gone left on Barstow. And we know from some of the footage that we saw that his car was seen flying past, true, not hitting one at this point, but flying past. There's no logical understanding for Mr. Brooks other than he's in the middle of a parade and he can see them. Anyone driving a vehicle would see what's ahead. And we know from this map, right, what was ahead of him. We saw that video footage. We heard the testimony. Many police vehicles at these intersections with their lights flashing. There's no doubt in my mind that Mr. Brooks would understand a parade was going on. You can turn off my monitor. Thank you. We also know it was not yet dark. Dusk. This was from the battalion chief who talked about when he arrived after that first alert at 4:39, it was not yet dark, it was dusk. I think that aids to the visibility that of these people. This is not under cover of night. It's of course downtown Waukesha. We saw city lights in many of the street lights I'm referring to in many of the videos as well that would have been on or coming on. We know just past Barstow, he strikes his first victim, Nicole White. She was with REMAX Services with the hot air balloon. If anyone's seen that, we saw it in the video. That is unmistakable what that is. That would get anyone's attention. If this was a mistake, if he was lost, this was his very first opportunity to stop and do the right thing after causing injury to a person. But he didn't. He did not stop. And then, of course,
And no, he's not
walk into
fanning
something.
himself.
It's hard not to think about what I watched and not have this reaction. Those were images that frankly kept me up at night, that I saw over and over and over. For their band director, she is a hero to me, to get up on the stand, to talk about, and that was Sarah Waymeyer Aparicio, to identify each one of her students, talk about their formation, talk about what she saw. So strong for all of you. Mr. Brooks had another opportunity to stop. This wasn't one isolated person that he could claim, I didn't know I struck someone. This was driving over people. What Kyle Jewell described as the SUV went over people like they were big old speed bumps. I know the Green children were injured around there. Thankfully, their physical injuries were minor, and I know I could probably spend a long time talking about the injuries of the band members, and I'm not going to go through that. They were significant. It was horrific. Thankfully, none of them were killed. And then, of course, moving on to Burr's Logistics, between the band and the Blazers, that is where Kelly Graybow and her 10-year-old daughter, Adelia, were in that adorable Cindy Lou Who costume. And what struck me, and Kelly referenced this in her statement yesterday, was seeing the tires go past her head after she was hit. Adelia had major injuries as well. And then, of course, the footage from the Waukesha Blazers. And Jeff Rogers talked both at the trial, he testified, and he gave a statement yesterday about, again, having to come into this courtroom, talk about all of those who were with him, who were injured. And of course, little Jackson Sparks, another video that frankly is very difficult to watch and hard to unsee. You heard not only Jeff, but Josh Craner talk about what happened. And Josh, of course, being struck. And then the extreme dance group. I think it's fair that I didn't fully understand the extent of their injuries until hearing from yesterday.
Why is it
That's what it
pausing?
looked like. It was
Right.
horrific. And to think of those two brave young ladies who got up during this trial to testify about what they saw, what they did, Jamie and Alyssa, your dancers are proud of you. And because of you, justice has been served. We heard from others, spectators, Deborah Ramirez, regarding herself and her son, that the vehicle was accelerating, not stopping. A moment that sticks out to me was really Mr. Brooks trying to chastise her for not seeking medical attention right away. Her response was perfect. She waited due to the number of injured and all the blood she saw. Understandable. Not something. And I should call them lowlights, not highlights, but some of the testimony and evidence that really, really impacted the court. Stephanie Bonesteel and her husband testified about what Citizens Bank was doing, hearing the impact against Jane, a very loud thud and an audible gasp from the crowd. Her husband, Adam, was driving the support vehicle. And when he was being cross-examined about why he didn't see the driver, again, he just simply said, I thought it was my wife that had been hit. All I saw was the red poncho. And the only time we ever heard about brake lights was when Jane Kulik was on that vehicle and he braked so he could get her off the top and run her over.
If you guys haven't listened to the witness statements I've put on my channel, please go back and do that. You'll
We
hear a
heard
lot
from
more
Matthew Harris,
information.
who talked about the red SUV coming straight at them and then veering and going in the direction of the dancing grannies. And again, that audible gasp as he described that eerie sound. He saw a
Or
child
didn't do,
injured
Bob Kidden.
in front, Jane Kulik behind. Actually, the child and Jane Kulik behind, and two victims ahead. He saw two of the dancing grannies. What he described as the SUV traveling faster than the speed limit. What I wrote down from his testimony is he's a combat vet, and this is what he said. I've never saw anything like this in such a safe. You could tell he felt bad about not seeking treatment right away for his daughter. He talked about how his wife's a nurse practitioner. And again, he didn't want to direct resources from other victims, that we thought she was okay enough to be home with them. Now, by this time in the parade, it's very clear the spectators are noticing something is not right. The sounds, the atmosphere has changed. There's screaming, there's gasping. There's a noticeable difference. It's at this point, I believe that Owen was struck, Kelsey was struck. Probably another miracle given the injuries she sustained, with a tear in her spleen, significant road rash, cuts, requiring facial surgery. What Mr. Knapp described the driver as having eyes completely wide open. And then next we heard from Laura Thien, one of the dancing grannies. She talked about the sisterhood. Another brave woman came in, talked about what happened to that group. 7 people injured from her group, 4 fatalities. Happened in a matter of seconds. All I seen was bodies. It looked like a war. The 6 people who were killed suffered multiple blunt force traumatic injuries, severe, significant, some dying instantly. I was impressed by both Dr. Bidzricki, for her attention to detail, her looking at that vehicle, inspecting it, looking at the heights where certain damage was done, and it being consistent in height with the individuals that she did the autopsies on. And of course, Dr. Scheel, and both of these individuals have testified before me, but Dr. Scheel, very shaken from the autopsy of little Jackson Sparks. We then, continuing on, heard from Father Witter, very gracious man. He too talked about how he noticed something unusual, saw an SUV flying down the road, heard thuds. It was faster than anyone in their right mind would be going. He estimated it to be over 25 miles per hour. And then Lucas Hallmark, the off-duty police officer who was walking with his family on that day. He talked about the commotion behind, the large amount of screaming. You could feel it was palpable when he testified about having the wherewithal to try to get his kids out of the way, throwing his 3-year-old as far as he could out of the way. You could see the pain on his face when he talked about not being that successful with his 7-year-old. He said, "I wasn't quick enough." He testified that he thought this was a terrorist act, that SUV did not stop. I referenced the speed already, the ACE speed estimation from Detective Carpenter, 33 to 34 miles per hour, a little bit more than that. The speed calculation by Michael Smith from State Patrol from farther down the route of averaging 32 miles per hour. And then, of course, the vehicle inspection by the State Patrol, finding no mechanical issues. There was also the Franklin Assistant Chief who attended the parade. He was near West Main Street in Maple. He provided the testimony regarding the SUV, the window being open, and the driver sticking his head out, looking out. He testified how he thought perhaps it was either a medical emergency, maybe even a mechanical issue, but it was clear once that SUV passed him and he saw that driver, he saw you, Mr. Brooks. No panic, no distress. His heart sank. He knew it was not a medical emergency. The body language just didn't fit. It did not believe it was mechanical at that point either. And then he saw the vehicle crank to the right. As he testified, he seemed excited about what he had done. Another off-duty police officer, this one from Wauwatosa, talked about how he saw Mr. Brooks after the fact crash the vehicle, hear him yell out an expletive and run southbound with his sweatshirt still on. We all saw that video. Of course, at one point, Officer Skolton had contact. And as he testified, he put things together. Keep in mind all of the radio traffic, right? About one person, then like 15 people and another 15. It was very apparent to him that although he was on the far end, he was around the dog leg on Wisconsin and Maine, that a vehicle had driven through the parade. He saw this vehicle. Of course, at that point, it was heavily damaged. He made the decision to use deadly force. What did he do after? What did Darrell Brooks do after? We crashed the vehicle. He fled the scene in a hurry. He changed his appearance, took off his sweatshirt, loses his shoes, I think in a hurry to get out of there, not caring that they had fallen off. He puts his hair up. We saw that on a number of videos. He asked unsuspecting people to use their phone to call an Uber, all within minutes of all of this happening. He was in such a hurry to get out of there, he left his phone in the SUV. He calls his mother, who arranges for an Uber. We heard from the Uber driver. He never showed up. It was nearby, ultimately, where he was found. And then, of course, the ring footage of his contact with Daniel Ryder. That is at 5:01 p.m. Minutes after all of this happened. Mr. Ryder was astute, noticing that after Mr. Brooks being in his home for maybe 8 to 9 minutes, he saw squads driving by. I think you could say his gut told him something wasn't right. And he had Mr. Brooks go onto the porch, of course, after having given him a sandwich, given him a coat to wear, ultimately asks him for his coat back. And then, of course, the arrest. This is where some of the lies become evident. Mr. Brooks claims ultimately when he's being interviewed by Detective Carpenter, they have to actually seek medical clearance for him because he claims that he was thrown to the ground when he was arrested. He was not. The video is very clear. He cooperated. He laid down. There was no use of force used at all to take him into custody. But we know ultimately that he lies about what he was doing in Waukesha, how he got there, who he was with. He lies about having contact with Erica Patterson the day before. We know when he's found, he has the Ford Key credit card, not only in his name, but one, whether it's a credit card or like a benefits card, but it's in the name of Erica Patterson, and of course an ID for himself, a state issued ID. The Ford itself is registered in his mom's name. It's the same address that's on his ID, and there was documentation found in the Ford Escape. He's now in custody. He's taken to the substation, ultimately taken to Waukesha Memorial Hospital. What's notable, the video and audio clips that this court reviewed from the hospital, Mr. Brooks is calm. He's coherent. There's no obvious signs of impairment, no obvious signs or really any signs of mental distress. He makes statements that he's not from the area. He doesn't appear disoriented or confused. At some point, there's kind of a jovial atmosphere between him and one of the detectives. The next day, he lies to Detective Carpenter, denies driving to Waukesha. I got a ride. He makes up the story about a tan Kia. He's very nondescript and vague with the information that he provides. And over the course of those 5 hours, he never once references the parade. He never once says there was another driver. Of course, they start talking to him initially about the domestic altercation because by that time, it's very clear a link had been made between Erica Patterson and the call that police originally received of the domestic, or at least an altercation near Frame Park and Mr. Brooks. We also know because of the bond conditions in the 2 felony cases, he's not supposed to have any contact with her whatsoever, but he does. At no time, 5 hours on November 22nd, does he make any admissions? Does he show any concern for any of the victims? No empathy, only lies, only concern for himself, for his family. Can I have a phone call? He does not provide, and I said this already, the name of anyone else that could
He
be
wasn't
driving that
concerned about
vehicle.
his family, just himself.
At one point, Detective Carpenter says, one of two people drove through the Waukesha Christmas parade. Either a God-fearing person who screwed up or the malicious guy. Darrell Brooks's response is, don't spin it. One of the things that has become abundantly clear throughout this trial, Darrell Brooks understands exactly what he's doing. His comprehension is fine.
Yep.
I have absolutely no concerns and have never had any concerns throughout this case and throughout this trial, or even through the past day and a half regarding his competency. He's intelligent, he's deliberate, he's purposeful. He made nuanced arguments during this trial about the right to counsel versus the right to the assistance of counsel. That's a sophisticated legal argument, not the product of someone who doesn't understand. He asked questions on cross regarding tint, horns. He brought up the recall after the fact. He talked and asked questions about, question about barricades, police being at the intersection. Although we never fully understood what his defense was, what became very apparent to me as I reread through all of my notes is that from the very beginning, he wanted to argue jury nullification. If you go back to his opening statements, he talked about power and the jury doing the right thing. He repeated that theme during his closing statement. At one point, he objected to evidence based upon a violation of one of the court's pretrial rulings. Again, a pretty sophisticated objection that resulted in the court striking an exhibit that had previously been received. Today, he spent close to 2 hours talking on his own behalf without any notes. He covered a variety of topics. I want to talk next about, here's my note that I found. One more thing on Mr. Brooks. You know, at times, right, we've seen the eye rolling, the fake clapping, the laughing, hand
Patting.
gestures,
Patting the heart.
many
all that crap.
times and most times very emotionless. Unless he's doing those things, which would be really inappropriate and are inappropriate, his reactions are largely negative when things are not going his way.
He knows he's screwed at this point.
What did this community suffer as a result of this tragedy, this malicious conduct by Mr. Brooks? Well, I think many of the victims who spoke said it best. Lori Locken described it as this: a sense of personal safety you robbed from us. I believe it was Bill Mitchell who said, the only life he seems to value is his own. Jason referred to it as evil. And he talked about innocence being stolen. He called the defendant a coward. No remorse. Look like a monster. You look disrespectful to court and witnesses. You look like a callous jerk. But I forgive you.
That is strong.
Such character. Such compassion. Margaret talked about the mental, physical, and emotional toll this has taken. She talked about how it was so traumatizing that her mind won't let her see everything that has happened and that she's worried when her mind might allow her to do that. I'm thankful that she's 95% back to normal. She talked about emotionally every day. She's reminded of the physical pain and the loss of self, but she's had tremendous support from family and friends, and that today she will move on. Jeff Rogers also commented on the lack of remorse and sympathy for the victims, how he has had to relive just the immenseness of this, the confusion, the anxiety, depression as a father, and irritation. He talked about how his son, Caden, was so concerned for his younger sister. I'm really glad Riley is okay. I believe that was from the day of the parade. And how he recognized he was inches away from losing 3 of his 4 kids just because of where they were located. He had flashbacks of grabbing his daughter's jacket, missing the first time, but that Riley gets up sometimes 6, 7, 8 times a night. How this was supposed to be a happy kickoff event for him as their new president, and how after it happened and in the aftermath, the weight of the moment, and 35 people there trying to find everyone, weighed on him. He talked about the media showing up at his door and the emotional toll things have taken. It was intense, and speaking at Jackson's funeral. He talked about how his faith is stronger. Again, very gracious, very inspiring. We heard next from Jessica and Juan, and how this impacted them, the loss of their son's friend, Jackson. Their kids were involved in 2 different groups that day. One, a dance group, not the extreme dance group, but a different one. And then, of course, the Blazers. And how, I believe it was Jessica who said, I yelled stop. I put my hands out as if I had the power. How she saw Jackson, and how she will forever have that image burned in her memory. And that she was so grateful when she found her son, how she covered his eyes to shield him from what was around. Not once, but twice they had to run, because first it was what happened through the parade, and then the active shooter situation, because of obviously people didn't know who had fired the shots in that moment. And she talked about pain and terror. Many people talked about PTSD. I mean, for her, I was really struck by how difficult it has been because of what she saw, not able to be a teacher, how she's hyper vigilant, and every sound sends her into a panic, how her joy has been stolen, and how she does her best to hold it together for her kids. But when she was alone, she cried, she screamed. And only a month ago was she able to return to work, but in a very different capacity.
Oh, goodness. Can you imagine?
She commented on the lack of remorse by Mr. Brooks, and that he seems to search only for sympathy for himself. She said he will always be a danger to society. We heard
Well
from more
said.
individuals. From the Blazers, again, a lot of discussion of PTSD. The sights and sounds of the SUV plowing through, the impact to her and the kids, the nightmares, how parking lots are problems, there's panic attacks, that no one will ever be the same. Of course, we heard next from the Sparks family. They're hurt, angry, they're traumatized, they're broken. It was difficult to even watch them make Their hurt is palpable. She talked about her last hug with Jackson, the horrible sounds she heard. She saw a police officer holding Jackson. She went to Tucker, and then her world came crashing down. She talked about how she found a hat, both boys' hats, then shoes. And I didn't realize how significantly Tucker had been injured until she described that for us yesterday. How Tucker somehow blames himself for his brother's death. It's not your fault, Tucker.
Oh my
It's
gosh.
Mr. Brooks's fault.
Bless his heart.
One of the things when there is a fatality with all of these victims is the future that is robbed from them, right? No future weddings, no future graduations, no future grandchildren or children, no plans. It's just gone. It's all memories. And the contrast with, frankly, what Mr. Brooks will have, and that is even a life in prison, he'll make memories, he'll have phone calls, he'll have visits. He may even get to hug the people that he loves again. For the 6 individuals who lost their lives, that will never, ever be a reality. And that this family also talked about the lack of empathy, lack of remorse, no apology. I'm aware Mr. Brooks wants to come back. It says, I don't intend to interrupt in any way. That's not a pledge. He needs to pledge that he will not do so. I need that word in that statement. And if he does that, I'll bring him back in. I'm going to try to go a little bit faster. Some of the comments, the yells and screams from that night will haunt me for the rest of my life. I'm asking the court to give the max for each conviction because he has given the community a sentence of these memories. I think it was Tyler's mom who talked about the community rising like a phoenix.
Yep. It's an amazing
Clearly
community.
have a phoenix for a son. He's strong. He got me a little bit with his comments. Wasn't expecting that. You're an amazing young man. You're a picture of resiliency, of fortitude, of strength. I think what this community needs. I thought it was quite a testament that you took those pictures and the same pictures of Jackson. You replicated that, and I thought that was a great tribute to him. You talked about, of course, rising up with Eric, who had significant injuries as well, both of you, and how you fought back and each were able to play baseball to the full capacity that you had done previously.
Do you guys think he's even
And
thinking?
then we next heard from Sasha,
Like any of this makes him stop and think at all what he's listening to from her?
who's haunted by survivor guilt. My heart breaks for her. She talked about feeling empty, how she couldn't play soccer because her kicking leg would hurt from the injuries she sustained. She has difficulty sleeping, struggles with nightmares. Physically and emotionally, she feels stuck. She talked about maybe law school being in her future. And to her, I say, don't give him the satisfaction of holding you back. Rely on your friends and your family and be the phoenix that Tyler's mom spoke about. Jen Dunn read a statement from Sasha's mom, and I wrote this down. No one knows what it's like to stand on your feet when there is no floor. That's a pretty powerful image. I think that's very apt for what this community has gone through. We heard from others, including the Teagues. We saw photographs. So many families with more than one individual who was injured. How baseball for Eric was stolen, how he was such a good player. We heard a lot about night terrors and, again, PTSD and trauma. One of the individuals talked about humor is good medicine, and I would echo that. We heard about one band member whose instrument may have very well saved his life. Someone described it as a mental massacre, though, the aftermath of this. It's difficult to go downtown. It's difficult to get restful slumber. Panic attacks, common. Describe Mr. Brooks as sheer evil in its vilest form. I wrote down that despite all of the impact and carnage, many people talked about forgiveness, brokenness, sorrow, anger, hatred, regret. A lot of emotions, frankly, really no emotion shown by Mr. Brooks, certainly not for what he did on November 21st. We saw a lot of anger for some of the people who lost loved ones, and understandably so. Many families were devastated. Nannies and grandmas were taken away. Yes, there were very specific terms used to describe Mr. Brooks, that in their opinion, he's a monster, he's a demon. Pure, unrepentant evil was one of the phrases that were used. Talked about the system failing us. Saw you in your SUV hanging out with a smile of satisfaction on your face.
Oh my gosh.
For one of Leanna Owen's sons, I lost my mom, and I wasn't always a good son.
Oh.
You can hear, right, the regret in that statement, because life is short, and these lives were taken far too short. We heard the very gracious statement from Michael Carlson, who, unbeknownst to me, had been writing Mr. Brooks in jail and sharing the gospel and the love of Jesus. He read a poem, which I thought was beautiful, from the standpoint of his sister. And he said this. In that poem, it says, "We both died that day. I, Tamara, died to life. You died to the world." And then, of course, the Sorensen family talked next. They talked about never seeing their Grammy again. You murdered my mom. But at least I have some peace knowing she died doing something she loved. We heard from Brooke yesterday and today. She reread her statement due to the interruption. For getting up here and sharing that. We talked about how compassionate each one of these individuals who died were. We heard about the compassion from Detective Casey that we learned about. It said Detective Casey came to our home to verify what we knew, and then he greeted us every day of this trial. They ended with, angels watch over us. 6 angels watching over us today. They asked me to hold Mr. Brooks accountable so that he will not have the opportunity to hurt anyone ever again. We heard from the Kulik family about the empty space that they have and the brokenness, their lives being shattered by mom and grandma being taken away. We heard from her youngest daughter among them. The grief was so palpable, being 17 and in high school as a senior, now a first year in college. She talked about all of the things she will never have with her mom. Just the last year alone, an 18th birthday for her and her brother, graduation, and beginning college. She lamented that her mom would never see her do her wedding vows, never see any kids that she would have, be a grandmother. She wouldn't be able to call her parenting advice. And how excruciating it was for that family to wait 3 hours because of the chaos at the hospital.
Can you imagine,
Talked
you
about
guys?
triggers of their PTSD, sirens, things of that nature. And how she waited. She waited hoping that Darrell Brooks would have a reason. She also said this: no verdicts don't bring my mom back. No more hugs, no more dinners, no more talks. My mom was the glue that kept our family together, and we are falling apart. Moving on, Leanne talked about her safety and security being stolen by this defendant. She asked Mr. Brooks to picture his own daughter, unresponsive, lying on the ground with a leg injury, a head injury, and blood coming out of her mouth. She talked about the excruciating 2 weeks in the hospital, wondering if her daughter would ever live, in a wheelchair and then a walker for months. She said this: all you had to do was hit the brakes.
Let's stop. Yep.
Her daughter talked about being scared of everything, worried about a sister, being alone in a church for 3 hours on lockdown because of what was happening in the aftermath. And we heard next from the Urell family. A family that, of course, was impacted significantly with 4 of their children, all of their children being struck by the SUV, with the mom, of course, having to testify, in this case being called by Mr. Brooks, which, of course, was his right to call witnesses. But it's the manner in which, I think, the indifference, not caring that this was someone who had 4 children impacted significantly. But clearly, you're raising your kids the right way. With grace and dignity, Charlotte got up and talked about the basic things you learned in kindergarten. She described what she saw as being stupid, delusional, and egotistical. She wanted to punch you in the face, and understandably so. I think her words were, "Your arrogance is pathetic." And her mom echoed those words. And then the gut-wrenching survivor guilt that you heard from her mom. She goes, "I say this with a heavy heart. I have my kids here. I had to fight for my children. They will strive." And then, of course, we heard from Alyssa in her heart-wrenching statement. She, of course, testified bravely, but you could tell the impact that this had on her and what she saw in the aftermath to the extreme dance team. How one of the girls who at 10 years old, even lying on the ground, being injured, had the wherewithal to ask, why would someone do this? If a 10-year-old knew this, then the defendant knew this. And how she left the hospital not knowing if she would see some of her girls again. She was completely and utterly broken, forever changed by this event. She waited. She talked about how she for remorse, for empathy. It didn't happen. Dylan Urell said something very insightful yesterday, something we didn't hear about in the trial, but because of where he was at on the parade route, around the corner, waiting for his children. He didn't even know that all of them were in the parade. He said this, you hit the brakes to go around the corner. And then you drove through a barricade where an officer shot at you 3 times. Those brakes were working. You knew how to use them. And you selfishly only used them so as to not crash your own vehicle as you fled the scene.
Exactly.
Talked about walking through and around that corner through the wake of carnage, bodies all over, women, adults, children deceased, people running all over. We heard from more of the members of the extreme dance team, either directly or parents and loved ones, how they had to walk through the carnage to find their children. Such a gracious statement of love, talking to Mr. Brooks about being a Christian and how she prays for him. Very powerful. Thank you for that. Her daughter, equally as powerful and brave and gracious. But even she knew, she said that I thought about you every day. How could someone do this? Victims talking about PTSD, how even the song that was playing during the extreme dance team performance is a trigger for her PTSD. And how she's forgiven him. We heard from the sister of victim HH and how the first thing she talked about was the sound of Vivian Urell whimpering, crying, and then she found her sister, how her clothes were ripped off. She was unconscious, half naked. How she felt forgotten because her mom was at the hospital with her sister, of course, due to the severity of her injuries. How her sister was in a coma for 2 weeks, but how she has survivor guilt and issues like that, panic attacks, PTSD. She can't be around fireworks, tires screeching is a trigger. That this turned her life upside down. And then, of course, we heard from victim HH herself. So brave to come here. I'm so very thankful you are recovering. Someone commented on how amazing it is to see the many people with their in recovery. You wouldn't know by looking at them, of course, the emotional and mental injuries are significant and severe, but so grateful. Frankly, lucky to be alive. I say to you, that scar on your neck should be a sign of strength and fortitude. You fought, you won. You have a story to tell. Don't shy away from it. Of course, we heard from her mother as well. We saw that PowerPoint with the pictures of their journey. The road rash on her face was horrific. You can only get a mental picture from words so much, but to see those actual pictures, her being intubated, and it's heart-wrenching. And all of the surgeries and the toll it took on their family. But she described her daughter as a warrior. I think all of you here are warriors. We heard from Sam and her family and what she went through and how significant her injuries were. And her mom talked about the haunting vision she has of just what she saw because of her perspective. Sitting in the back of the pickup truck, she had a seat, a front row seat to horror. How she thought her daughter was dead because she was unresponsive, and blood, and really kind of the chaos and the confusion, and not really even being able to articulate what happened over the phone to her husband. She described what happened as careless and reckless. Asking Mr. Brooks, how could you do this? What kind of father does that? The last person we heard from was victim F. If I have it reversed, please excuse me. And how you could, I actually have her written statement that was provided earlier today, but how she was so taken aback by the conduct of Mr. Brooks that she frankly called him out on it yesterday, because he was kind of motioning his hand like, okay, come on, let's get this over with, hurry up. She yelled at him, you don't care. She goes, you hit me, I saw you, you knew, you're a child killer. She was so flustered, she had to really gather herself before she could continue. So again, I want to thank the victims. I have other statements that I've read for people. So gracious. I think they were all members of the Catholic communities. Their statements were translated, very gracious, praying for.
Sorry if
So I
I'm
just wanted
buffering, guys.
you all to know that I've taken all of these statements into consideration today. I can't read your sign, Mr. Brooks. Can you hold it up closer?
We don't care what your
If
sign
it's a
says.
pledge that you will not interrupt me, I will bring you in for what will be the final section of my remarks today in the sentencing portion.
I think you should give them that opportunity before you go through the
I'll do that.
sentencing factors. And I can only read the top word says objection, but
I can't tell what it is, what it says. He can bring the sign with. We'll clear the courtroom. We'll take a short break, and I will bring him back in. But I will warn you, Mr. Brooks, that there is one interruption. You will go back to that room because you will forfeit your right to be present for the sentencing portion. We'll be in recess until we can get him back in. Thank you.
She did get a little, I don't know. She kind of did one thing, said another over here coming up, but she just wanted him to be in the courtroom, guys. He needed to sit there and listen to this, and she wanted to be looking at him when she gave him
Mr. Brooks is back in this courtroom. Mr. Brooks, the only way I will honor that request is if you specifically waive your right to do so. Without that, that's not a convenience for you over there. It's you go over there when you frankly demand removal under Illinois versus Allen.
Didn't demand anything.
No, your conduct did. So you
My
can
conduct
sit.
didn't demand anything either.
Right, Mr. Brooks,
You
please
keep
sit
changing-
down.
You keep changing
And I'm
the
going to continue
jurisdiction.
with my sentencing remarks.
He's an
Keep
idiot.
changing the jurisdiction. Jurisdiction, it's a subject matter jurisdiction that has yet to be proven on the record. In
Mr.
that court
Brooks?
and in this one.
Please sit down.
I would like
See to you. If you'd like to specifically waive your right to be physically present, then I will entertain that. Otherwise, you need to sit
I
down.
never waived the right to not be present.
That's
I
because
had
you
to-
forfeited your right
I
to be
didn't
present
forfeit
by
anything, Your
conduct.
Honor.
You're
I
now
wrote-
back in this courtroom.
Your Honor, I wrote 3. I did what you asked me to do.
You
said,
never once pledged to me, sir, that
No.
you would not interrupt. And
You-
you're demonstrating by being here that you continue to interrupt.
man, I ain't trying to hear all that, because at the end of the day, I did what you asked me to do. You told the bailiff to tell
Mr.
me.
Brooks, this is not a debate.
You told the bailiff to
It's
tell me
not
that
a
I had
debate.
to
You
write.
asked to come over here and I honored that.
Well,
and
I
I brought you
exercised my
back.
right 3 times. I shouldn't have had to do it 3 times.
None of those opportunities that you wrote to me said, I pledge to not interrupt.
I never
Judge
had to do
Dorow."
that before. You've never required that before.
That is actually not true, sir.
You've never required that before. Every single time that I've been brought over there, after some time, sometimes very short, sometimes an extended
Brooks,
period of time.
You are just simply trying to delay the
I'm-
inevitable. Please sit
I
down.
don't care about the inevitable. It was
I need
already
to
written
get
from day
through
one
this
what was going to
hearing.
happen. That it doesn't make me lose any sleep about that. I know I'm okay. I'm okay with everything.
Then please
I just
sit
want to
down.
be. I just want to be treated fairly, which I have
Please.
not been.
Please
He's
sit
okay.
down.
And
You hear
then
that? He's
Your Honor,
okay.
And then you
Mr.
always make it seem
This is
like
not a
you always
debate.
make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign.
Mr.
I'm
Brooks,
waving this for like 20 minutes,
You're-
saying I would want to come back. I'm doing this.
You're
Hey,
here now.
Can I come back? Can I come back? Can
So
I come
sit
back?
down.
It wasn't honored. And then I
So I
said,
can
okay,
finish.
I'll write this and I'll see if Your Honor can see it on the screen. The objection sign saying, I
Mr. Brooks,
exercise my right
if
to
you
be present.
stop for a
May I have
minute,
the order of the court?
I'll explain it, but you have to stop so I can explain it.
Your Honor, I did what you asked me to do.
Actually not.
Yes.
Let me explain.
And if
you would like.
If I didn't, Your Honor, if I did not do what you asked me to do, then why was I allowed to come back if I did not do what you asked me to do?
Because I'm frankly going to a very distinct portion of this hearing where I am going to impose sentence.
Okay, that doesn't
and
answer
that
the question, though, Your Honor.
matters.
That doesn't answer the question.
Please sit down and I will explain and
Your Honor,
remain quiet
with all
without
due-
interrupting me.
With all due respect.
That doesn't mean you're respecting me, so
you-
please
you-
sit down.
With all due respect, you told the bailiff when I first said, because every time that I've been brought over there in the past,
Mr. Brooks,
you always stated
I don't need a history
always
lesson of
stated
what I've done.
that when I exercise my right to be present,
Untrue.
you've
Untrue.
always said, we
Untrue.
have the record. We have the record. We can dig into the record.
Mr. Brooks,
I know what the requirement was of me going over there. You've always stated on the record that when I exercise my right to be present, you will bring me back if I will follow the rules of decorum. That's your exact words, which you said every time.
which you're
I've never-
demonstrating
I've
right now
never
that
had-
you have absolutely
Your
no
Honor,
ability to do.
With all due respect, I've never had to go through any type of certain words that needed to be said or stressed or anything like that before. I've always done it the way that you've asked me to do it. No different than today when I told the bailiff I would like to be present. If he wants to be present, he has to put it in writing.
And pledge
I
to
put it-
me
I
that
put
he
it
will
in-
not interrupt me
I put it in writing.
without a pledge.
So why am I here?
Because I'm going to move on to another phase of this hearing, and I thought it important that you be here in person,
So I was here.
but you didn't reclaim your right to be back here,
Then why am I
I
here
am
then, Your Honor?
allowing it to
Okay,
happen.
and I respect that you're allowing it, but still, it doesn't answer the question, Your Honor. It does not answer the question.
Mr. Brooks,
Your Honor, as a
Mr.
public
Brooks.
servant, I have the right to ask questions
Sir.
of Your Honor.
I'm going to ask you one more time, and if you refuse to sit down, then you are in direct disobedience of a court order. Sit
That-
down and be quiet so I can make the appropriate
Can
record.
you tell me what the
All
court
right,
order
he's
is?
not going to obey. He's now
I
forfeited his
didn't say
right
I
to be
wasn't going to
present.
obey.
He will go into the
I
other
didn't say I
courtroom.
wasn't going to obey.
We'll be
I
in
just
recess
asked what is the
until he's
order.
there.
I just asked what is the order. I didn't say.
Chocolates. Pull on the chocolates. I agree, y'all. There should have been some there. Some people need them. Not everybody, not every prisoner, but some do. Yeah, I'm here. Who was asking if I was here? I'm here. The monster changed the lives of people outside of Waukesha. He's upset that there are Facebook groups about him. Yes, there are. They are great. And you know what? Not to give him any soapbox, but I think he even likes the bad attention. Isn't that crazy? Of course, what has he got to look forward to now? He's just sitting there waiting around. And he's going to sit here and do all this knowing she's the one that's fixing to
Thank you.
sentence
Please
him.
be seated.
But I guess he's smart enough to know he knows where she's going with this.
Of course, I do need to first verify that they can hear and see us. I'm getting the thumbs up. We are back on the record to reflect that Mr. Brooks is no longer in the main courtroom. He is in the adjoining courtroom. I, of course, have been erring on the side of constitutional caution, but I would note that his right to be present at sentencing is a statutory right, which frankly, I probably don't need to go through the findings under Illinois versus Allen, but I did. But under whether it's a statutory right or a constitutional right, you can forfeit that right. And his behavior today has certainly demonstrated that he has forfeited his right to be present in this courtroom. During my sentencing remarks, he immediately came in. I was on the bench looking through my paperwork. The courtroom wasn't even open. And he started asking me questions. I said I wasn't going to answer them. He really had no respect for the proper decorum. I needed it to be on the record. He didn't seem to care about that. Wanted to debate me about my prior rulings. Bottom line is it's a statutory right for him to be present, and he's forfeited that right. And I would just add that it's part of a pattern that has been demonstrated in this trial, that when my perspective, things are not going in his direction, things are being said that he doesn't agree with, that he tends to act out, he disrupts, and I'll leave it at that. Once again, I'll confirm he can hear and see. We've got confirmation from the staff in the other courtroom. One of the reasons I really spent the time going through both my observations of Mr. Brooks in terms of the mental health related issues, and first, and then going through the victim impact statements before I go through all of the necessary factors for sentencing, is frankly, it's challenging to talk about the impact to the victims without getting emotional. This trial is unlike anything that I've ever been a part of. The sheer magnitude of the crime, the number of people impacted, how they were impacted, the vicious, senseless nature of it, and hearing about the impact of all of that on our community members and the people who were at the parade, it's heart-wrenching. And I wanted to do that before I really got to sentencing, because I also thought it was important to really spend some time recognizing and acknowledging the impact to the direct victims who are in this courtroom and who have provided statements. Today, my focus in sentencing will be about November 21 of 2021, the events shortly before that or leading up to it, and after, and are not about Mr. Brooks's conduct during this trial, even though case law is very clear that his conduct at trial can and is a legitimate factor for the court to consider. I need to make the record very clear that in no way what I do here today is based on Mr. Brooks exercising his right to a trial. That is a firmly embedded constitutional right, which I support, which I upheld. Of course, every person charged with a crime has a right to a trial. This court honored that right. I protected that right, even if Mr. Brooks treated it with contempt, disrespect, and at times like a game. But sentencing today is directly related to his conduct on November 21 of 2021 and the other sentencing factors, which, as I indicated previously, include the seriousness of the offense, the need to protect the public, and his character and rehabilitative needs. Today, I am tasked with sentencing Darrell Brooks for 76 counts related to a couple of moments in time. Moments that are tragic, moments that were frankly avoidable. My sentence here today is, the purposes of it are twofold, really threefold if we think about the community. One, it is punishment. Two, protection of the community. And three, what I hope is justice and closure for the families and the community at large. I, of course, want to recognize and give due respect to the guilty verdicts that were rendered by the jury in this case. Not just 76 guilty verdicts, but the special verdict questions that they answered, including for counts 1 through 6 and 7 through 67 that had the special verdict question related to the use of a dangerous weapon. So let me talk about the seriousness of this offense. The seriousness of the offense can be summed up, frankly, in one word, and that is attack. There is nothing, no other word
He
that
hates
can
that
best
too.
describe what happened on November 21 of 2021 than the word attack. I talked about during my remarks regarding the trial about the opportunities Darrell Brooks had to avoid this altogether. I put Exhibit 15 on the screen for a bit, which is the exhibit that details the map. The map of the parade, it starts with White Rock. It shows where Sergeant Warner was at one point, farther up that parade route, the staging area. And I believe if you look further up on Exhibit 15, it even depicts where White Rock School is. And that, of course, is where we saw the video of the altercation between Mr. Brooks, Corey Runkle, Nicholas Kirby, and Erica Patterson. Now, of course, there were moments in time before that, but that is really where things started, where I believe Mr. Brooks boiled over with rage and anger that he chose not to control on this date. He had a number of opportunities to simply drive in the other direction down White Rock, but he chose to drive toward Main Street, even though from the testimony We know it was very evident that it was staging for a parade. There were many people, may not have been exactly by the school, but farther down White Rock. From Niagara forward is where that staging area was located, and many people were there. The sights and sounds of a parade, the signs on the side of the road telling people not to park there, for example. Instead of turning around, instead of turning left onto East Main Street or left onto Pleasant, and despite Sergeant Warner trying to flag him down and being in front of a squad with lights, right, a clear indication you should listen to or honor the even gestures of a police officer, and he was in uniform. He drives down White Rock Avenue and has contact with Detective Casey, who very clearly did everything he could to stop Mr. Brooks. And in that moment, thinking it's a lost motorist. But Mr. Brooks chose to basically brush him aside with that SUV and drive on to Main Street, past more people, past many spectators, and in a manner that was not just at a speed inappropriate for a parade, but frankly, that was reckless and endangered anyone who was on the roadway at that time, whether or not he hit anyone between White Rock and Main and Barstow and Main. But during that 3-block section of Main Street, he could have turned off Buckley, Northeast Avenue, Martin Street, or in either direction on Barstow. He could have stopped, asked for the police barricades to have been removed, or frankly, turned his car around even at that point and gone back the way that he had come. But he didn't do that. He chose to drive recklessly, carelessly, and maliciously through a parade route and at anyone in his path, where he struck not one, not two, not three, but 68 different people. We actually know that number's higher because we now know, we heard from the 2 individuals who were with Extreme Dance, the one girl who was struck by one of the individuals who was clearly struck, and that person flew into her. That would qualify upon the state's description of how they chose to charge. It's just they didn't know until closer to the sentencing hearing. So 69 individuals if you include her. There are so many aggravating factors here, it's frankly difficult to even keep track of them all. The complete disregard for the lives of anyone else that day. Someone described it as depraved indifference, and I think that is the perfect phrase to capture the actions of Mr. Brooks on November 21st of 2021. The aggravated factors of the numerous opportunities to turn around or not even enter the parade route or simply to stop. The fact that he mowed over and used that vehicle as a battering ram to hit 68 individuals, never once stopping, with rage and anger at unsuspecting people at a parade who were there simply to kick off the holiday season, to experience joy with their families. The intentionality of the conduct is outstanding. The viciousness, the speed, the swerving from side to side at various points. This was not a case of whodunit. From the very beginning, from when this case was charged, it was clear who did this. Now, that is not to say that I prejudged this case. I did not. But after sitting through this trial, after watching the many videos, after listening to the testimony of the many, many dozens of witnesses, it is clear the state had overwhelming evidence of Mr. Brooks's guilt. What's also aggravated is his complete and utter lack of remorse. He spoke here today for 2 hours. One sentence, that's it. I'm sorry. No detail. 2 hours, one sentence. No empathy for any of these individuals, at times mocking them with hand gestures or rolling his eyes multiple times. That is not an indication or a sign of someone who has empathy.
I'm going to get
for
chills
what
here in a minute.
he has done. We may never know the true why, but we were provided with nothing here today other than a feeble attempt to blame mental health, which frankly does a disservice to those who truly suffer from mental health issues. I understand why his family might cling to that because of the difficulty in coming to grips with a loved one doing such heinous things. But for Mr. Brooks, it's nothing more than indifference, deflection, and outright denial of what he did and the impact that he has caused as a result of his heinous actions. I searched for a mitigating factor in this case. I waited patiently for an apology, true. I didn't get it. And not for my benefit, but for the
Yep.
victims.
That's why she kept letting him back in.
The law allows me to look at things such as Mr. Brooks's prior criminal history, including the history of criminal offenses and pending charges, the history of undesirable behavior patterns, which can include dismissed, uncharged, or unproven offenses or facts, even including expunged offenses, not really relevant here. Acts resulting in probation revocation. Of course, those are part of his criminal history, nothing specific to these charges. I can look at his personality, character, and social traits, the vicious or aggravated nature of the crimes, the degree of his culpability, his demeanor at trial and truthfulness, his age, his educational background and employment record, his remorse, repentance, and cooperativeness, his need for close rehabilitative control, the rights of the public, the recommendations of the interested parties, including victims and family members of homicide victims. I can consider statements made by his own family. I can certainly consider the length of pretrial detention, which I'd note, though, when facing 6 life sentences, is really a fraction of the time available to this court. The loss of life in this case is certainly one of the aggravating factors here today. The number of people injured, also an aggravating factor.
Thank you, John Anna.
The
John Anna.
reach into the community,
I'm sorry if I butchered your name.
certainly palpable because this was a Christmas parade. I think it was a comment earlier, either today or yesterday, that this was not like one act where Mr. Brooks drove into a crowd of people. This was sustained driving from block to block to block to block, picking off people that were unsuspecting. 68, 69 times. Driving over people as if they were nothing more than speed bumps. What's also aggravated is his conduct after he drove through the parade.
Hey, Coffee.
Crashing his vehicle in an attempt to flee. It's pretty evident based upon the evidence and testimony from trial that Mr. Brooks had no idea there were these logs in that backyard that could damage his vehicle. He was attempting to flee when he ran over them, and it ultimately disabled that vehicle. And he was forced to abandon it. He ditched it, leaving personal identification information in it and his phone in a clear attempt to get out of there in a hurry. And then we have that series of videos that we saw at trial of him going through backyards, coming in contact with people, asking to use phones, ultimately ending up at Mr. Ryder's home, who graciously took him in. Never once, Mr. Brooks showing any signs of distress, of any emotion of what he had just done. Cool, calm, collected. Certainly not a sign of someone who had any remorse for what he had just done. Someone who's involved in an accident, even a tragic accident, one where they flee the scene and are later caught, oftentimes show incredible remorse, tears, not tears for themselves, but tears for what they've caused, a recognition of the loss of life, for example, from their conduct. Nothing. An individual who simply wanted to flee. That is the epitome of consciousness of guilt evidence. Fleeing, changing your appearance, taking off the sweatshirt, not even caring that your shoes are off your feet because you're so intent on fleeing the area, putting your hair up from it being down. No doubt, this is by far and away one of the most aggravated cases I've ever presided over. The sheer magnitude of the loss, the number of victims, the types of crimes for which the jury has convicted him. 6 counts of intentional homicide, 61 counts of first-degree recklessly endangering safety, 6 counts of hit and run, 2 counts of felony bail jumping, 1 count of misdemeanor battery. What's further aggravated is the fact that he was out on bond. He should have had no contact with Erica Patterson. But the rules mean nothing to Mr. Brooks. Nothing. He didn't care. This was someone who on 2 prior occasions, charged with, frankly, causing mayhem. 1, a reckless endangering safety for discharging a firearm. Other for battering and then running over Erica Patterson's foot. This court does get to consider the other act's evidence that the state sought to introduce at trial. That other act's evidence includes that on November 2 of 2021, Milwaukee police took a complaint from Erica Patterson that Mr. Brooks had run over her with his vehicle and tried to kill her. She had tire marks on her right pant leg. She could not move her leg and had blood coming from her mouth. On that date, Mr. Brooks was driving the same vehicle that he drove through the parade. Erica Patterson was conveyed to Frederick Memorial Hospital. Her injuries received medical attention. She even had that boot on her leg on November 21 of 2021. She described Mr. Brooks to police as yelling at her, using profanity, as she tried walking past him when she was at a gas station. I think initially before that, at another location, but ultimately where he allegedly ran over her was at a gas station and caused the injury to her leg. Struck her in the face once with a closed fist, causing pain and bleeding without her consent. And then it was after she walked away that he followed her. When police had contact with him, he denied driving his mother's vehicle. When police had contact with him at his house, he ignored their commands because he was found in the vehicle, claiming that he was having an anxiety attack upon the sight of the squad car and needed to get into the home to get his inhaler. When I say the rules don't matter to Mr. Brooks and court orders mean nothing, Mr. Brooks was in custody, and there are jail phone calls where he's berating Erica Patterson, encouraging her to recant, blaming her for what had happened, saying things on that phone call like, "You trying to make it seem like everything is always everyone else's fault but yours. Like you don't never do anything to cause shit. And the whole cause of this shit was something that you fucking did." He ended the call by telling Erica Patterson, "You did this shit and you couldn't even keep your mouth shut after numerous people told you that shit. This ain't the place for you to be doing this shit. And you still ran your mouth. And I'm the one sitting in here facing all this time." Repeatedly calls her a bitch. During a phone call on November 11th, Darrell Brooks is overheard or captured saying, "Why in the hell would I just try to mow her down knowing I could kill her like that? Like, okay, I probably got a few screws loose, but I ain't hardly no goddamn fool." He's complaining that she won't help post his bail. "You didn't put a cent on my bail. Why should someone else have to pay for some shit you caused?" The end, apparently, of that conversation, or at least moments later, he says to her, "Nah, I didn't try to do anything, because if I tried to do something, you wouldn't be on the phone now. That's what you're not realizing. If I really tried to do something, you wouldn't be on the phone now. That is the rage and the anger that Mr. Brooks had on November 21 of 2021 when he tracked down Erica Patterson, confronted her. This wasn't about him getting money from her, like he lied to Detective Carpenter about. This was to confront her. He clearly hit her. We know that. This is the type of man that drove through the Christmas parade, enraged because, frankly, it's entirely possible that Corey Runkle and Nicholas Kirby saved the life of Erica Patterson. It's clear Mr. Brooks was hell-bent to cause harm to her, but she was able to get free, run back to her friends. Who knows what would have happened but for their intervention? If you think back to the testimony of Nicholas Kirby, he felt bad. Mr. Brooks, like somehow this was his fault. He was just trying to be there for his friend, someone he recently met. So, Mr. Brooks, that other act's evidence is a very clear indication of your poor moral character. It demonstrates unequivocally that you have absolutely no remorse for anything that you do. You have no empathy for anyone, and that you are justified in the actions that you take. In addition to that conduct, as part of your character, this court is able to look at and consider your prior record. And I'm well aware, sir, that you're raising an objection sign, but you have forfeited your right to be here, and I will not stop, and you will not be brought into this courtroom. I will continue. This is his prior record, going back to two thousand, spanning what? Nevada, Georgia, at least police contact in Georgia. We have an unknown disposition in Wisconsin. Substantial battery in 2000, party to a crime. Put on probation. Ultimately, that was revoked. He went to prison. 2002, felony possession of THC, jail time. 2003, resisting obstructing, jail time. 2005, a disorderly conduct ticket, but he failed to pay the forfeiture and ended up serving an alternative to incarceration. Sorry, he ended up serving for failing to pay 30 days jail. 2009, obstructing, 2 days jail, meaning he lied to police. 2010, strangulation. Battery was dismissed and read in, put on probation, ultimately revoked, serving 11 months jail. 2012, misdemeanor bail jumping, possession of THC, with a number of other charges being dismissed and read in, 180 days jail concurrent. Also in 2012, a misdemeanor resisting or obstructing. So either he lied or he fled from police or did something to make their job more difficult. 37 days jail consecutive. In Nevada in 2006, domestic battery, a suspended sentence, obstructing after being found guilty at trial, for which he served jail time. 2007, statutory sexual seduction as a felony. This is for impregnating Erica Patterson when she was a minor. 2016, charged with not being in compliance with the sex offender registry requirements for which there is an outstanding warrant. In Georgia, a 2021 arrest for battery, domestic violence, presumably with Erica Patterson based upon where she came from at that time. But I won't make it, I say presumably, but frankly doesn't matter who it was with. We also know that there's the 2003 paternity case out of Waukesha County. Why is that relevant? Because 8 times during that case, a warrant has been issued for contempt of court, meaning for failure to pay his financial obligations to a child or children. The pending cases for which one pending case, I should say, he was, I don't believe, charged with bail jumping for that one. The 20 CF 2550, 2 counts of recklessly using a weapon, felon in possession of a firearm, released ultimately in March of 2021. He's accused in that case of firing a shot. There were two occupants in a vehicle. One was his nephew, and when he was picked up by police, a loaded Beretta, 9mm, which had previously been reported as stolen, was found in his possession. I already talked about the other acts evidence, that is the for which he was charged with felony bail jumping, the second-degree recklessly endangering safety for allegedly running over Erica Patterson, the battery DV, DC DV, and a resisting obstructing.
Still moving that
And then
arm.
the second,
Good gracious.
he was charged with intimidation of a victim, felony bail jumping for conduct on November 8th. So November 2nd, November 8th. This is clearly someone with a demonstrated violent history and past, someone who has absolutely no regard for anyone but himself. To say that he is a lifelong criminal, I think is accurate. He disobeys
no,
law
Tammy.
enforcement, he disrespects court orders, and he certainly demonstrated that he has no respect for these proceedings. Multiple acts of violence, violent, dangerous behavior that predated the attack on the Waukesha Christmas parade. His character, or lack thereof, is also demonstrated by his complete and utter denial of culpability in this case. His blaming of his mental health or alleged mental health. There's no evidence that he was suffering from a manic episode. I went through all of that earlier today, going through the 4 reports related to the special plea of those doctors found support for his special plea. Mr. Brooks talked about at times
He never gives up.
this being the will of God or that all things happen for a reason. I'm here to tell you, Mr. Brooks, you are not an instrumentality of God.
Bam.
Death may be inevitable to all of us, but you cut the lives of 6 individuals short. You alone, Mr. Brooks, cut the lives of these 6 innocent people short. I talked earlier about how I believe he's intelligent, deliberate, and purposeful in what he does.
Amen, Bama said.
I've considered that you have treatment needs. Perhaps there are intersecting mental health issues as it relates to your personality disorder, but those issues can best be addressed in a confined setting. The Department of Corrections will be charged statutorily to evaluate you and to provide any medical or mental health treatment that you need. This is a case that falls squarely on the need to protect the community. I referenced this earlier. There's really three primary reasons for the sentences I will impose here today. One is punishment, one is to protect the community, and the other is to provide justice and closure to the victims. Because category of need to protect, the court does get to consider the impact of these crimes on the victims. I went through at length in reviewing all of those victim impact statements. I certainly didn't go through every single one, just highlighting some of them, but doing so with purpose, because it is very clear to this court that Mr. Brooks has caused carnage, mayhem. It has resulted in many people suffering from PTSD, from mental and emotional trauma that will take a lifetime to recover from, and for some, perhaps, if at all. You have taken away from these individuals future memories. They will never have birthdays with the 6 individuals who were killed. There will be no weddings. There will be no graduations. There will be none of the milestones that these families were looking forward to, whether it be for an innocent 8-year-old or an innocent 79-year-old. Frankly, Mr. Brooks, no one is safe from you. This community can only be safe if you are behind bars for the rest of your life. The actions of Darrell Brooks demand punishment. The community is not safe from your violent and criminal conduct unless you are in custody. You left a path of destruction, chaos, death, injury, confusion, and panic as you drove 7 or so blocks through the Christmas parade, never once stopping or seemingly caring about the wake of carnage that you left. 4 of those blocks were turned into a scene that frankly is no different than a war zone. On counts 1 through 6,
Here we go.
this court is imposing a life sentence without the possibility or eligibility for extended supervision consecutive to one another. 1 life sentence for Virginia Sorensen.
Oh, I have chills. You guys
1
have
life
chills?
sentence for Leanna Owen. 1 life sentence for Tamara Durand. 1 life sentence for Jane Kulik. 1 life sentence for Bill Hospital. And 1 life sentence for Jackson Sparks. I've considered the enhancer and the additional 5 years that I could impose, but I don't need to really order that because I've not made him eligible for extended supervision, and it would only be to increase his time on initial confinement. But make no mistake, Mr. Brooks, you use that vehicle as a battering ram, no different than, frankly, a firearm. On count 7 through 61 counts of first-degree recklessly endangering safety. These charges alone and these convictions without the enhancer carry a maximum of 12.5 years. Because of the enhancer, a total of 17.5 years. And under Wisconsin law, the 5 years is added to the initial term of confinement. So what could be 7.5 years is a maximum of 12 and a half years. And I'd ask that everyone no longer show any reaction to the sentence so I can get through this. On counts 7 through 67, on each count, I will impose a total sentence of 17 and a half years. 12 and a half years of initial confinement, plus 5 years of extended supervision, consecutive to any other sentence that I've imposed here today. That is 762 and a half years of initial confinement and 305 years of extended supervision on top of the life sentences that I've imposed. That is 17 and a half years, sir, for Nicole White. 17 and a half years for Eleanor Anders, 17 and a half years for Sasha Catalan Castillo. 17 and a half years for Maura Gilchrist. 17 and a half years for Justin Gullickson. 17 and a half years for Harry Guilfoy. 17 and a half years for Aiden Lofgren. 17 and a half years for Theo Maza. 17 and a half years for Tyler Pudliner. 17 and a half years for Connor Tank. 17 and a half years for Eric Teagues. 17 for Adelia Maffioli. 17 and a half years for Kelly Graybow. 17 and a half years for Josh Craner. 17 and a half years for Riley Rogers. 17 and a half years for Caden Rogers. 17 and a half years for Tucker Sparks. 17 and a half years for Isabella Bartlett. 17 and a half years for Yaritzi Becerra Montez. 17 and a half years for Samantha Coelho. 17 and a half years for Madison Hollingsworth. 17 and a half years for Mackenzie Hollingsworth. 17 and a half years for Mitchell Lampine. 17 and a half years for Kathleen Kielmeyer. 17 and a half years for Julia Schleichow. 17 and a half years for Olivia Stover. 17 and a half years for Jennifer Stover. 17 and a half years for Jesselyn Torres. 17 and a half years for Alice Urell. 17 and a half years for Charlotte Urell. 17 and a half years for Vivian Urell. 17 and a half years for Grayson Urell. 17 and a half years for Lola Hospital. 17 and a half years for Tamara Rosentreader. 17 and a half years for Betty Strang. 17 and a half years for Maria Alvarez Dominguez. 17 and a half years for Gregoria Romelia Perez. 17 and a half years for Elliot Hallmark. 17 and a half years for Benjamin Hallmark. 17 and a half years for Patrick Heppy. 17 and a half years for Lori Locken. 17 and a half years for Marisol Lopez Gutierrez. 1.5 years for Adair Lopez Rubelar. 17 and a half years for Juan Marquez. 17 and a half years for David Marquez. 17 and a half years for William Mitchell. 17 and a half years for Jason Petchloff. 17 and a half years for Margaret Pachulis. 17 and a half years for Yamilet Perales Alvarez. 17 and a half years for Island Perales Alvarez. 17 and a half years for Ash Alvarez. 17 and a half years for Jose Perales Alvarez. 17 and a half years for Maria Perez. 17 and a half years for Camila Perez Gonzalez. 17 and a half years for Isaac Foglia. 17 and a half years for Deborah Ramirez. 17 and a half years for Charles Green. 17 and a half years for Lily Green. 17 and a half years for Brinley Harris. 17 and a half years for Kelsey Knapp. 17 and a half years for Owen Braciotti. On count 68 through 73, which are the 6 counts of hit and run resulting in death. These are 25-year felonies each. The court will do the following. On count 68, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision. This will be concurrent to count 1. Count 69, the same sentence, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 2. Did I say that the right way, the first one? Okay. Count 68 is concurrent to count 1. Count 69 is concurrent to count 2. Count 70, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 3. Count 71, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 4. Count 72, 25-year total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 5. And on count 73, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 6. On count 74 and 75, the 2 felony counts of bail jumping, the court is ordering a 6-year sentence total on each count, 3 years of initial confinement, 3 years of extended supervision, consecutive to all other counts, but concurrent with one another. And lastly, but certainly not least, the maximum sentence for the battery to Erica Patterson, 9 months consecutive to any other sentence. To order anything other than what I have done, sir, would be to undo the seriousness of these offenses.
Yep.
It is needed, although largely symbolic, given the number of years that I have imposed here today, because frankly, you deserve it. I know it's symbolic, but it needs to hold you accountable in a very real and tangible way. For all of these sentences that I have imposed, I will order the following conditions: no contact with the victims as identified in the amended victim key or their families, no contact of any kind with Erica Patterson. You are to pay restitution in the amount of $47,193.29 to EMC Insurance Company, that's on behalf of the Waukesha School District, and $124,000, $220.65 to the Crime Victim Compensation Program. I am ordering DNA surcharges on all counts. On counts 1 through 75, it's $250.
That's all?
On count 76, it's $200 under the law. I'm also imposing the domestic abuse surcharge on count 76 of $100. I'm also
Domestic
imposing
abuse
all
should be
standard
more.
court costs on all counts. Although my primary emphasis is that restitution be paid before costs, surcharges, and fees, I will order that restitution, costs, and fees be paid out of prison money. In other words, that all financial obligations shall be collected pursuant to statutory provisions as requested by the state. That's frankly a standard, it's customary, but it will be in the judgment of conviction. And then pursuant to 949.165, I'll find that it is appropriate for this court to order an escrow account under 949.165 for payment of restitution, costs, fees, surcharges, and even for costs associated with prior legal representation or future representation under the statute. Mr. Brooks has been convicted of a number of serious crimes for which this section is appropriate. I will order 360 days credit As to count 1 and count 68, only. All other counts, 0 days credit because of the consecutive nature of the sentences that I've imposed here today. I calculated that with my sentence calculator. Of course, that is through yesterday because these sentences commence today. There are a number of advisements I must go through. First of all, Mr. Brooks will be provided with a written explanation of determinate life sentence regarding the first-degree intentional homicide charges. Of course, he's not eligible for release to extended supervision. That form defines extended confinement for him, and there's other language on here that he can read at his convenience. He also will be provided with the notice of right to seek post-conviction relief form. The court will fill out the caption for him. He is instructed to review it and review the defendant's acknowledgement, make the appropriate selection, sign and date it, and return that to the court. I must advise you, sir, you have been convicted of a felony. That means you may not vote in any election until your civil rights are restored. You may not possess a firearm. You may not possess body armor. Both of those are punishable as felonies. You also have 20 days from today's date to appeal the decision of this court. Does the state believe I've overlooked anything here today?
No, thank you, Your Honor.
First quiet
All
time
right,
we
those
saw
documents will
proper
be
quiet.
provided to Mr. Brooks. I will note for the record at many times during remarks, he was holding up an objection sign. That objection is noted for the record. This now concludes this hearing and this case. We are now off the record.
Do you want to do the motion stay pending appeal, or
And
we could do it
I'm
another?
gonna
Amen.
wait till I sign the judgment of conviction. I'm not making any determinations regarding where he is to be held. That certainly is within once the judgment of conviction is signed, I'll address the motion for stay pending appeal. But my understanding is he needs to be transported to Milwaukee, and I will not stand in the way of that. All right, I'll schedule that once the judgment of conviction is signed.
Understood.
We are in
Thank you.
recess. Thank you, everyone.
whew, that was a long one, but it just makes me happy every time I watch it. And I think there's so much with this trial that we all just, like Bama was just saying, you watch it over and over again, and every time you pick up something different. Thank you, Sarah, darling, for another super chat. You're awesome. You guys are awesome. Look at you. Boom, bam. I know. Look at how small he is around those guys, y'all. Isn't that hilarious? I wonder if the prosecution and the judge all went out for a drink afterwards. Probably not, but you know what? Separately, maybe they went and had their own little drink. You know what I'm saying? Yes, we are still waiting for Milwaukee to do the right thing, and I do have the live stream up on my channel if you would like to go to it at any point in time. It's under my lives. Just go in there and click that thing so it'll notify you when we do go live the next time. Let me look real quick. I think it's with the 30. Oh, I've already forgotten. Hang on. All right, so October 31st, Valentine's, Halloween. It's Halloween Day. And that's just a hearing. It's just the status hearing. That's all it is. We're going to see the new attorney come in, and let's see if he's done anything different. Before that, though, we'll be back with Suitcase Sarah on October the 2nd. And again, that's probably just a hearing. But at least we know now that Suitcase Sarah. Let me go back up here. At least we know now that Suitcase Sarah is going to have a trial before the end of this year, which we did not think was going to happen. Can we watch the presser that took place right after? Oh, yeah. You want to do that? Hang on. I got to find it. One moment, please. Please hold. following Danielle Brooks's sentence. Yeah, let's do the one from the Milwaukee Sentinel Journal. This is let's see, that's 18 minutes. How long is this one? Let me make sure I get the right one. This is 11 minutes. Yeah, we'll do the full one. Okay, hang on. I gotta pull this up and I gotta present that. And I gotta turn my sound on for you guys because I have it turned off.
Also, good afternoon, everyone. We're here to have a press conference to discuss some of Good afternoon, everyone. We're here to have a press conference to discuss some of the events that happened today. Speaking today will be District Attorney Sue Opper, Chief Dan Thompson of the Waukesha Police Department. Also, David Sorensen, which is the husband of Virginia Ginny Sorensen, Tyler Pudliner, he's a Waukesha South band member, and Amber Conkey, a mother of one of the juvenile victims. Also present with us today is County Executive Paul Farrow, the prosecution team consisting of Leslie Basie, Zach Witchow, Detective Casey from the Waukesha Police Department, Detective Ryan Rugland from the Waukesha Sheriff's Office, and paralegal Christy Giese. Also to my right, your left, is Jen Dunn and Carrie Peterson from the Waukesha County District Attorney Victim Witness, and with our comfort dog Pepper, who have played
Aw,
an integral
Pepper.
role
I love
with
Pepper.
our crime victims throughout this whole process. To that, Sue Opper.
Thank you. First and foremost, our thoughts and concerns remain with the victims involved in this tragedy and their families. Although the defendant devastated our community, the people of the city of Waukesha, Waukesha County, and beyond demonstrated tremendous resiliency. We are so grateful for the first responders, citizens, and medical professionals who sprang into action and immediately rendered aid and saved so many lives that day. We appreciate the jury for their work and dedication to justice. We commend the police officers and citizen witnesses who testified or were prepared to testify and asked to relive the events of that horrific day. We are satisfied that this defendant has been held accountable for his actions. He now faces imprisonment of 6 consecutive life sentences plus 859 years of confinement. There is much healing ahead for the victims and for our community, but we hope today's result is a step further along that path. Remain strong, Waukesha. Thank you.
Amen.
Waukesha Police Chief Dan Thompson.
Thank you. 2 days we'll never forget. November 21 of 2021, on that tragic day, and October 26th of 2022. Why October 26th? Because justice was served today. I want to say thank you and praises to this community. I want to say thank you in the resiliency and strength of the families and victims who were involved in it and were impacted by this event. The investigation team, I want to send a personal thank you to the District Attorney's Office, Sue Opper, Leslie, Zach, and everyone on that team who assisted in this successful prosecution. I want to say thank you to the jury and the court process and the court proceedings and everyone that was involved in the court who found this defendant guilty, which is just and right. That defendant's actions did not define this great community. It refined us in our resolve and our strength in being Waukesha strong. Thank you.
David.
I got it. Thank you. I'm David Sorensen. These are my 2 sons. Justice was served for my wife, Virginia Sorensen, my 3 children, and the whole Sorensen clan. Thank you very much to the people that did this court case. We appreciate it. Sean or Marshall wants to say one little thing.
We've been praying for this day for a long time, and this morning my 5-year-old daughter came up to me and handed me this necklace with my mom's ashes in it, and she told me to take my mom with us for the sentencing. So she was with us today. I just want to thank everyone for what they did today. And one last thing, my mom always used to tell us when we were kids and our family that she always said, angels watch over you guys. So I just want to say angels watch over you guys and turn on those blue lights tonight.
Thank you.
I want to first thank the prosecution team. They were the one that got us to this point. I'm thankful for all their support along the way and getting us to this day. It's been a difficult day. I know that this will give us healing. This is another step forward in this process. We've been resilient all the way through. One of the things that I've said so much throughout this is that we're stronger than him, and it's been proven today. It's just another step forward in the process. So I want to thank Sue, Zach, Leslie, all those guys for their hard work, Jen and her staff, and especially those first responders. It's been brought up. They are the ones that especially kept me here, gave us a second chance, and they've kept our community strong. So yeah, Waukesha strong. As Marshall said, he touched on it. Keep those blue lights on tonight. Thank you, everybody.
Amber.
Just want to say that I'm very happy with the verdicts and that, you know, justice has been served today. I would just like to thank everybody, the first responders, the DA and the judge, all the law enforcement, everybody who was involved, especially those who were very much involved with my family and the support system that we have had. It's been amazing to see how wonderful this community has been to pull together for all of those who were hurt that night.
Thank you. With that, we'll take a few questions. Those available for questions will be Chief Thompson and District Attorney Sue Opper. So I'll start right here, TMJ4. Who would you like to direct your question to?
You see it? You see up there in the top right? That's
How are you and your team?
what's her name?
Well, it's obviously quite satisfying that Mr. Brooks has been found guilty and held accountable for his actions. As many of these victims have said, this is a joyous day for that reason. It's also the point where we hope everyone can move on from. The support that we've gotten as this case wore on day after day was tremendous. And we're very relieved. I guess that's the best word, is relief.
Hillary?
I saw you get a tear in your eye when they were talking about Virginia's ashes. You spoke about what this meant to you and the victims. How do you begin to describe what it was like going up against Brooks as defending him, representing himself? Did that change your strategy? How did you get through all that?
Yeah. I mean, legally, it changed our strategy, certainly, because if there's an appeal, he can make a mistake in the courtroom and get a new trial. And we have to pay the price for that, we, the state, and we, the victims. So it's changed our strategy in that we had to make sure, and Judge Dorow did as well, the record was very thorough, very complete, and we didn't miss anything. But as far as handling the actual court proceedings, we felt very, very offended by his behavior, his disrespect of the court, the decorum, the families, his insulting the judge, his challenging the judge. That's not the way our system is designed. That was intentional on his part. We truly believe that. He did everything he can except claim that the dog ate his homework. And he tried to turn this into his story. Let's talk about Mr. Brooks and his family. And we just kept redirecting it back to the real focus here is our families, our victims, our community, and his responsibility for this destruction.
58.
What was the most challenging part and how did you keep your patience through all of it?
Again, it wasn't a difficult case factually, and I don't mean to sound, overly confident in that, but this case was unique because the activity was videotaped, right? And so whereas most cases we have to rely on eyewitness accounts or other ways to prove the case, we had videograph evidence of his behavior all up and down that crime scene and throughout the neighborhood. So that way, it wasn't difficult. Again, the difficulty and the challenges we faced was what nonsense was going to come out of his mouth next. And we were anticipating much of what would come next and being ready legally with case law and legal authority to be able to respond to that. So I think that was the hardest thing. The investigation was so thorough, so well done that we knew the facts were solid. It was just making sure the record and the presentation was done legally accurate.
We'll do Fox Local.
So what went into your decision to perhaps minimize the number of direct witnesses that went up on that stand? And I wonder, did you expect any of these antics if that went into your decision?
Yes, it did. So obviously we didn't know until very late that he'd be representing himself. But we as a team set out from day one, and this was months and months ago when he still had attorneys, we vowed we would not put children on the stand. Absolutely. It wasn't necessary. Again, there were plenty of other ways to tell this story without asking a child to testify in a courtroom and relive this very, very extreme tragic situation. So that was a commitment we made as a team months ago, and we stuck by that. Certainly, as we learned his antics, we reevaluated, and we would discuss it every night as a team: is who are we going to use tomorrow, and do we really need this person? Because we were so, again, not personally offended, but professionally offended that he would insult the process and insult the victims, accuse them of financial gain for their testimony, things like that. It was just so offensive that we definitely were conscious of that in our decision making, and how can we minimize this for the best of everyone, but still provide a compelling story. So yes, it did definitely play a factor.
Court TV.
Thank you so much. Ms. Offer, there were so many victims' families inside the courtroom every day sitting behind you. How much did that motivate you and your team and how you present your evidence and your closing argument? You mentioned them. And have you been able to speak to any of them that aren't here that maybe said something to you afterwards?
Yes. The motivation we received from those families was tremendous. And we knew the point when Mr. Brooks chose to represent himself, this was going to be a marathon. We talked about that many times as a team, that we just need to keep moving forward every day, whatever that looked like. But what motivated us was these families that are behind me, a lot of them. And we thought of those mothers and fathers sitting in hospital rooms with their children and the ongoing care that they're still physically healing from and certainly emotionally healing from. And that motivated us tremendously. But you couldn't meet a nicer group of people. I mean, that's the thing, is I'm not surprised, having lived in Waukesha for 35 years, that they're good people here. And they would ask us, how are you doing? Do you guys need anything? Which was really phenomenal. They were a tremendous group of people to work for. And it was our honor to represent them and be a voice for them in the court.
Andrew Grannies, Spectator News. Yesterday, it seemed you threw Darrell Brooks a little bit of a lifeline when it came to presenting his closing argument. It seemed that the judge was going to kind of forfeit his right to do that. What made you go that route to allow him and then just object to what he was saying?
That was strategic for the appeal, to be very blunt. I wasn't throwing a lifeline to Mr. Brooks. I really had no interest in hearing what he had to say because I heard all of his lies and stories so far. So that was just trying to do what was legally required at the moment. And I frankly wasn't sure it was going to work because he was so difficult with Judge Dorow. But in the end, it did work. He got to blurt out what he wanted to blurt. And then the judge struck that from the record and we were able to move on. So I was glad that that was the result, but we talked about it at the prosecution table and came up with that idea of let's offer this again, just to protect the record for the appeal.
Jim.
Knowing what you knew going into this with Brooks representing himself, what caught you by surprise with what he presented?
Again, his absolute disrespect and dishonor to the victims, the community, and the court process.
I'll do Brian from the Freeman and then two more for, we'll do CBS and then, where are you from? Okay, those are the last three. So go, Brian, you got one?
Yeah, there's been some discussion since the verdict was announced that perhaps a decision to represent himself is grounds for appeal. Are you concerned at all about that?
Well, Mr. Brooks has a right to an appeal. Every defendant does. And I fully expect him to take advantage of his rights as a convicted defendant in this case. I am very confident in the record that Judge Dorow made and his decision to represent himself. Yes.
Go ahead.
Hi, I'm Roxanne, CBS News. What do you think about the length of time that the jury took to deliberate? Short, long, are you surprised?
We were not. We talked about it last night. And frankly, I know a lot of you were here too. We were all, by the time we got to that 8 o'clock mark, we were exhausted. And when they said they wanted to go home and rest, we were thankful, quite frankly, because we all felt the same way. It's such an emotionally draining day. And to get through all that and the nonstop banter from Mr. Brooks, it's taxing. You all witnessed it yourself. So we were grateful. We thought they gave it good thought because they went out around 6:30. Their dinner was there immediately, right? So jurors are human beings. They get a nice meal. They got a little time to talk. And then they decided, let's rest. Let's sleep on it. Always a good option for decision-making for anybody, right? Get a good night's sleep, sleep on it, and come back the next day. And then, they worked again for about another hour this morning. And with
this is after the verdict, not the sentencing.
In this case,
sorry, y'all.
We think
Did the wrong
verdict
one.
Was fair. The timing was spot on.
Go ahead.
There's a lot of people who aren't here today, of course, but a lot of people who are also at the parade on the day of the parade who aren't here. In closing, what do you want to say to them just at the end of this process?
Well, I hope some of you caught the flavor of that. You cannot imagine until you saw some of those videos how horrific it would have been to stand there and watch that. Especially when your children and some of these witnesses testified to that, they couldn't find their children, right? And that's not just people who were struck. That there was many citizens who could not find their own child for a period of time. So just unbelievable. But once the car went through and everybody had that initial, the way the citizens of this community punched in. There's no other word for it. The nurses, the doctors, the EMTs, the paramedics, anybody who knew anything about how to apply a Band-Aid walked into that street and treated those people. So that was another source of strength for us, right? Is if they could do that, we can get through this.
Okay, let me show you one other one. This is where she
Authorized
responds.
representative for my client.
Piece of crap.
Yes, first and foremost, you asked for max sentences. You got them on all of them. What sort of conversations do you have with victims? And I'm curious what you heard.
Obviously, everyone is very grateful and very appreciative of the time that Judge Dorow took to explain her sentence and explain the reasons why. I thought it was very, very impactful that she read a sentence for each victim by name. That was really tremendous. The victims are very grateful for that she respected and cared about each one of them enough to name them and, basically say to the defendant, you're serving 17 years for this person. You're serving 17 years for that person. So a lot of
a lot of tears and happiness, of course.
Judge Dorow brought this up that Brooks spoke for more than 2 hours and she never heard one sentence. She never heard him say that he was sorry to the victims.
Right.
What are your thoughts on all of that? On his speech on him not apologizing?
Yeah, I think we all had that same observation of he was allowed to speak freely for 2 hours and really much of it was irrelevant information that didn't help. She asked him pointedly several times, what do you think I should do? What type of sentence do you think I should impose? And he never directly answered the question. So yeah, I mean, the lack of remorse, the lack of responsibility are factors she can consider, and she definitely did. And it definitely was something our victims all noticed too, of course.
What were you feeling when everything came to a close today?
I don't think it's really entirely sunk in yet, but a little bit of relief just for our families that they don't have to keep coming back here. We've been very grateful that we were able to get this wrapped up in a year's time for our families and not drag this out for years, which you see so commonly.
Yeah, that was
It was very
amazing.
fortunate. The investigation was so well done, so thorough, so easy for us to just move quickly on charges and move the case along. So we're very, very glad about that.
Wow, that's awesome. I want to give a big shout out and thank you to Kathy Jones, John Anna, and Sarad for your super chats. Thank you so, so much. You guys are awesome. Thank you all for being here with me today. I appreciate your support. I know that this is, I haven't really sat through any of the trial with you guys like this before. And I thought if I'm going to do it, I got to do it on the sentencing, right? So I appreciate you being here. Please, if you haven't already, if you would hit that like button on your way out, it really helps me get past those walls on YouTube that keep me from being seen by other people that don't know about me yet. So, y'all, it is Friday and I am so ready for the weekend. I'm not sure about you guys, but I hope that you all have a wonderful, wonderful weekend and stay safe and take care of one another. Love you guys a lot. Thank you so much. God bless.